former U.S. Attorney for the District of North Dakota. The letter praised Judge Trainor's work in North Dakota community programs. The letter stated, quote, "He distinguished himself as a thoughtful and courteous partner for participants with diverse political views and those with no political views at all," end of quote, without objection. I hear none. It'll be entered in the record. I was wrong, not White House, Schiff. Go ahead, please.
Thank you, Mr. Chairman. Mr. Traynor, I just want to follow up on my colleague's questions and make sure that I understand this. You were asked a series of questions about January 6th, and correct me if I'm wrong because I was not here at the time you were asked those questions, and you declined to go into whether this was an insurrection, the nature of the attack on the Capitol, because you said it might involve a case or controversy that would come before you. Is that correct?
Senator, it did involve cases or controversies. We had people in the District of North Dakota that I believe were charged.
So you felt it wouldn't be appropriate for you here today to discuss your views on what took place on January 6th, is that right?
I stated that what I saw was deeply troubling, Senator. The attacks on law enforcement, any attack on law enforcement should be condemned.
So why are you reluctant to answer questions about what took place on January 6th? On the one hand, and on the other hand, you say judges don't forfeit their First Amendment rights. You feel free to write to a university to tell them who they should hire or not hire, who you're going to hire or not hire. You feel free to immerse yourself in that controversy. But here you won't talk about your views of January 6th. Can you reconcile that for me?
Yes, the difference, Senator, is that there is no case or controversy with regard to hiring of law clerks, but handling matters
Well,
that come
you're saying there's no case or controversy involving Columbia, involving the efforts by the administration to punish Columbia, all the litigation around Columbia, that wasn't the case or controversy?
That was far afield from the letter that was signed, Senator.
Really? Why is it far afield? Weren't you complaining about what was taking place on the Columbia campus, and as a result that you weren't going to hire law clerks and the other judges on your letter weren't going to hire law clerks? Wasn't that the nature of your correspondence?
Yes, that was the nature of the correspondence.
So you feel perfectly free to immerse yourself in that, exercise your First Amendment rights there, but when it comes to asking you basic questions about January 6th, you won't answer those questions.
The difference, Senator, is that there are cases or controversies that I have before me as a district judge relating to individuals that have been charged for conduct that occurred on that date in this Capitol.
So does that mean that any litigation involving Columbia you're prepared to recuse yourself from?
Senator, the limitation on Columbia was in regard to hiring law clerks. I hold no bias against the institution itself.
Well, whether you hold a bias towards it or not, you're saying today that you can't discuss any of the January 6th stuff because there are pending cases or controversies, even though they've all been pardoned by the president. I'm not sure what case or controversy you're referring to, but nevertheless, you're unwilling to say you recuse yourself from a case or controversy involving Columbia when you specifically weighed in there. How do we reconcile that?
Well, Senator, as I stated in the recusal order that Ranking Member Durbin raised, I indicated that I held no particular bias against...
Well, yeah, that's fine. You can say you hold no particular bias about January 6th, too. I mean, it's easy to say. Your letter demonstrates a very clear bias. I'm not saying that it's an unreasonable bias, but it is a bias. It is a prejudice in favor of one view that would cause people to question your impartiality if that case came before you. That seems to me a stronger, much stronger case for recusal than the one you're making to refuse to answer questions about January 6th. So let me just ask to make sure that I understand the limits of what you're prepared to say. Who won the 2020 election?
Senator, as I indicated in response to questions from Senator Blumenthal, Justice Ketanji Brown Jackson, as a sitting circuit court judge at the time of her nomination, was asked this question in questions to the record.
I'm asking you the question.
Yes, and as a sitting judge, I will tell you that it is not appropriate for a judicial nominee to engage in discussion regarding a matter of political controversy with that.
See,
which that
this is completely inconsistent with your involvement in the whole Columbia controversy. Completely inconsistent. Because you involved yourself in that controversy. You went out of your way. Nobody asked you to write that letter. You took this upon yourself to do, to insert yourself into that. But you're saying here, you can't answer a simple question about who won the 2020 election because it would somehow implicate you in controversy. I'm sorry, there's no way to square those two things. Mr. Chairman, I yield back.
Okay, now we go to Senator Whitehouse.
This exchange centers on one of the most important expectations Americans have of the judiciary: consistency. A judge's credibility depends not only on the decisions they make but also on whether they apply the same standards in every situation. That was the central concern raised during this line of questioning. The discussion highlighted what appeared to be a contradiction between avoiding questions about January 6 on the grounds of judicial impartiality while previously participating in a highly public controversy involving Columbia University. The point being made is straightforward: if a judge is comfortable taking a public position on one contentious issue, it becomes difficult to explain why another equally significant issue suddenly requires complete silence. Judicial independence is essential to maintaining public confidence in the courts. Citizens expect judges to remain above partisan disputes and to avoid creating the appearance that they have already formed opinions on matters that could come before them. When the standards for speaking publicly appear to change depending on the subject, it naturally raises questions about where those lines are drawn. Another broader issue raised here is transparency during the confirmation process. Senate hearings are designed to help lawmakers evaluate nominees' judgment, impartiality, and commitment to the rule of law. If nominees decline to answer fundamental questions while having previously spoken publicly on other controversial matters, senators are likely to question whether the principle being invoked is being applied consistently. Ultimately, the exchange underscores that accountability and consistency go hand in hand. Public confidence in the judiciary depends not only on judges being impartial but also on the appearance of impartiality. When explanations appear inconsistent, scrutiny follows, because trust in the courts is built on the belief that the same standards apply regardless of the political issue involved.